Hey everybody, this is John Skiba with the Arizona Consumer Law Group. And in today's video, I'm going to do something a little bit different. Many of the videos that I create for my YouTube channel and for my website are around how to deal with a debt collection lawsuit that's been filed against you, and usually by junk debt buyers like Midland Funding, Portfolio Recovery, all those companies. Usually I break up these videos into individual segments, like how to file an answer to a debt collection lawsuit, or maybe how to deal with a trial, or how to respond to summary judgment. In this video, I'm going to go through the whole process as it relates to defending a debt collection lawsuit in the state of Arizona, and specifically in the justice court system. Arizona has two different tiers of courts. They have the justice court system that handles cases where the amount in dispute is less than $10,000. And then they have the Superior Court lawsuit or Superior Court system, which handles lawsuits where the amount in dispute is over $10,000. So in this one, we're going to focus specifically on Arizona Justice Court debt collection lawsuits where the amount in dispute is less than $10,000. And that's by far the overwhelming majority of debt collection lawsuits in the state of Arizona. Now, the first thing that the debt collector will do is they will file their lawsuit with the justice court. And when they do that, they file the complaint. Now, the complaint is the document that has all the information in regards to what their allegations are, who the original creditor was, the amount that they're seeking, has all the basics of the information and what their claims are against you. This is where they're providing all their allegations and why it is they believe that they're entitled to payment. They will also get a summons issued to them on that date. Then they have to take the summons and the complaint, and they have to serve you as the defendant with the summons and complaint. Now, the Justice Court rules of civil procedure in Arizona allow the debt collector 90 days from the day they file it with the court to actually serve you with it. And I know this creates a lot of confusion, particularly when people are trying to determine when they have to file their answer, because they'll get served with the lawsuit and they'll say, hey, the date on the lawsuit was 2 months ago and they just barely gave it to me today. That date that they signed the complaint and they file with the court, that's not super important as it relates to you writing and filing an answer with the court. But what that is important is they have 90 days from the day they file that complaint and summons with the court to actually serve you with it. Now, service in general is done with a private process server, a person they hire who's going to come to your home and provide you or someone you live with a copy of the complaint and the summons. This is literally where they come by your house and put it in your hand. Now, it's important to know that they can also serve not only you at your home, but they can serve anybody who lives in the home with you, as long as they are of suitable age and discretion. That's what the rule says. And there's no specific cutoff. If your teenage kids receive a copy of the complaint and summons and don't tell you about it and throw it in the garbage or a basket by the door or whatever, that still counts. So it's important to know that just because they didn't put it in your hands specifically, or if you weren't home at the time when they came by, but they left it with somebody else who lives there, that counts. If they left it with someone who doesn't live there, that doesn't count. And obviously, if they went to the wrong address and gave it to someone who's not even involved in this, that doesn't count either. But it doesn't have to be you specifically. Now, often in these cases, we see where they can't get you home. The process server comes by and either you're not home, you're at work, or some people will intentionally try to avoid service by not answering the door. The reason why I generally tell people don't do that, don't try to avoid service, is because of what can happen next. If they can't serve you personally, they'll often go to the court and file a motion for what's called alternative service. This is where they're saying to the court, hey, judge, I can't ever get this person at home. We've tried in good faith to serve them. For whatever reason, we haven't been able to do so. So they then ask the court to allow them to, instead of personally serving you, they're going to send you a copy, certified mail of the complaint and summons, and they're going to come to your house and they're going to tape a copy of the complaint and the summons to your door. The justice courts in Arizona will almost always grant that. If the debt collector can show that they've tried in good faith to serve you and show that they have good information on you, it's highly likely the court will grant that. And the reason why that can become a problem is because often people aren't aware that they were served when it's done through an alternative method. Either they're not checking their mail, or they have a P.O. box and they just periodically check the mail. I've seen often where the complaint and the summons will be posted to the door, and then the wind comes up and blows it off and they never see it. And so the problem with avoiding service is that those motions for alternative service are almost always granted. And then once they're granted, you may not see the actual complaint and summons, but the clock has started ticking on your time to respond to it. And as we're going to talk about in detail, if you don't respond to a lawsuit in writing by filing an answer with the court, you're going to end up with a default judgment against you, where not only will they be able to collect on the amount that they're alleging are owed, like on the credit card, but there's likely going to be attorney's fees, court costs, and all of that's going to be entered against you. Then you're getting your wages garnished or your bank account seized, and you didn't even know that this thing had actually started. So in general, I say it's better if they're coming by the house just to take the complaint and the summons, and let's deal with it head on. So after service happens, it's important that you write down the day that you actually got served with the complaint and the summons, because that's when the clock starts ticking for you to respond in writing to the allegations in the complaint. This document that you file with the court is called an answer. Now, if it's fairly straightforward, if the process server comes by and puts a copy of the complaint and the summons in your hand, it's 20 days from the day that you were actually served with it. And the day that they drop it off doesn't count. So day one would be the next day. But after they serve you with that complaint and summons, it's 20 calendar days. It's not business days. It's not judicial days. It's just 20 straight days. That includes weekends, includes holidays, includes everything. Just 20 days that you have to file a written response with the court. So it's important that from the day you get served, you write down when that deadline is, because you need to respond to it. What about if you've been served through an alternative method? At that point, I always say start counting the 20 days from the day either you get the complaint and summons in the mail or that it's posted on your front door. Technically, the 20 days don't start ticking until they've done both, posted it on the door and mailed it to you. But I always say, just to be safe, whenever you receive the complaint and summons for the first time, that's when you should start counting your 20 days to file your response with the court. Now, the written answer that you file with the court is a fairly basic document. It's not something that you need to tell your whole life story in. And this is where I see people, when they file their own answer, where I see that they make the biggest mistakes, is that they view the answer as their opportunity to tell the court their side of the story. And so they go into a lot of detail they don't need. They start talking about job loss or medical issues that have come up that made it so they couldn't pay that particular credit card. At this point, you don't need to go into all of that. It's going to be important later on, but at this point, it's not. All the court wants to know is there an actual dispute that's going on between these parties? And so if you look at the complaint, there are numbered paragraphs, and each of those numbered paragraphs have one or more allegations from the debt collector as far as what they're suing you for. The court wants to know, do you admit or deny the allegations that debt collector has put in their complaint? And so you need to go paragraph by paragraph and respond specifically, stating whether you admit or deny the allegations that are contained within the complaint. And so the three best answers are yes, you admit them, no, you deny them, or you can say, I don't know. I don't have enough information right now to be able to admit or deny it. It's important you respond to that truthfully. When you're signing those documents, you're submitting them under oath, that the information that you're submitting is, to the best of your knowledge, correct. So you need to make sure that you are responding correctly. But in doing so, it's important to know that also, if you don't know, if they're saying that there is $5,600.10 owed, and you have no idea how they came up with that number, it's okay to just in your response to say that you don't have enough information to know whether that number is correct or incorrect. And so at this point, you're going to deny it until they provide additional information. Same thing goes with the junk debt buyer. With most junk debt buyers like Portfolio or Midland or Cavalry SPV, usually you're not in a situation where you ever entered into any type of contract. They didn't loan you money. You didn't agree to pay them any money. And so you're in this situation where you don't know if what they're alleging that they own the debt is true or not, because you weren't involved in that transaction and you don't have any information in connection with it at this point. So generally you can deny, and you can do so honestly, whether that they have ownership of the account, unless you have actual knowledge that they are the ones who purchased the account. If you have that knowledge, then you have to admit it. If you don't, then you're fine to deny it, or stating that you don't simply have enough information to admit or deny right now, and so you're going to go ahead and deny it. So once you get the answer filed with the, or drafted, it's important that you sign it, and then you're going to need to take the original down to the Justice Court, and that's filed with the court. There's also a filing fee that they're going to charge you. Right now, when I'm recording this in 2020, the filing fee is $68 that they're going to require that you pay right now when you file the answer. I always say to bring 2 copies of the answer with you, because you're going to get those time-stamped, one for your records, and the second one you are required to mail a copy to the lawyer who's representing the debt collector. You can find that information in the upper left-hand corner on the first page of the complaint. You're going to see the name of the attorney, their law office, and the address that you need to mail that. It's important you do that because the court is not going to do that for you. You're required to file the answer with the court, and then you are required to mail a copy of the answer to the opposing attorney. If you don't do it, you're going to see that they're going to try to move for a default against you because they're not aware that you filed the answer with the court. So it's important to mail a copy to them as well as keeping a copy for your records. Now, let's say that you don't file an answer with the court. Let me tell you how the default process works, because Arizona's process is a little bit unique. If you don't file an answer within the 20 days, what will happen is in the mail, you will receive what's called an application for entry of default. This document is the debt collector saying, hey, judge, nobody responded to this. We want you to enter a default against this person, against the defendant. And if you receive that, there's a kind of a grace period built in with Arizona's default process. If you receive an application for default, you then have 10 business days to file an answer with the court. And it's 10 business days from the date that they signed it, the date that they sent it to you. It's not 10 days from the day that you received it in the mail, but 10 days from the date that they signed it. So if you receive an application for entry of default, you can look at the document, look at the date that they signed it. You have 10 business days from the date that they signed it to file an answer with the court. This is kind of a grace period that they have built into it where you normally have 20 days to respond to the lawsuit by filing an answer. If you don't do that, it's not like on day 21 that default is entered. You're going to get this application for default, and then you have 10 business days, so you don't count weekends on when calculating that. And that's where it gets confusing. I know that the rules of procedure, they seem to be needlessly complicated, but when you're counting the first 20 days, you do count weekends, everything. It's just 20 straight calendar days. But if you get the application for default, you have 10 days from the day that they signed it to file an answer, and those are 10 business days. You do not count weekends or holidays in that calculation. So if you don't file an answer within those 10 business days, you'll then get another document called a motion for an entry of default judgment. And at that point, you've lost the opportunity to contest the allegations, and it's really just a matter of them submitting a judgment. The court's going to sign off on it, and they're going to give them everything they've asked for, plus attorney's fees, plus court costs. So it's important to get it filed within the 20 days. If you don't get the 20 days, but you get the application for default, then you have that 10-day window, 10 business day window to file the application or to file the answer. If you don't do it during either of those time periods, it's really done at that point. They're going to get a default judgment against you, and life's going to be pretty tough because once they get the default judgment, then they can do things like garnish wages and garnish bank accounts. So let's hope that you don't go down that route, but let's take it back and assume that you've timely filed your answer with the court. Then what happens? The next major deadline that you need to be aware of is the exchanging of what are called initial disclosure statements. The initial disclosure statement is basically this opportunity for both sides to really show their cards. When you go to trial in in Arizona, I should say this, in Arizona, when you go to trial, it's not like you see in the movies. There's no, gotcha moments or surprise moments. Everybody has to exchange all documents that they intend to use at trial. They have to exchange lists of any witnesses they intend to call at trial. All of that has to be exchanged early on in the process. So 40 days from the date that you file your answer with the court, the parties are required to exchange initial disclosure statements. Now, over at my website at consumerwarrior.com, we actually have a template that you can use on this. The court does have a template. I don't like it very well. That's why I created my own, but they do have a template that you can use in creating an initial disclosure statement. But really just walks you through what your side of the facts are, how much they're seeking. When they submit it to you, they're going to say how much they're actually seeking in their lawsuit. Both sides have to list any documents, provide copies of any documents that they intend to use at trial, as well as lists of witnesses or people who may have information about the lawsuit. Again, go over to consumerwarrior.com and you can see I have a template there that you can use for this. And once those are completed, like I said, they're due 40 days after the answer is filed with the court. Those are exchanged between the parties. They are not filed with the court. So you don't need to take your initial disclosure statement and submit it to the court. Neither does the debt collector. These are just something you're going to mail to the other side. They'll mail you yours. You'll probably get a big packet. It's not unusual often that defendants in debt collection lawsuits do not have a lot of documentation to exchange. It's generally what the plaintiff has. And this is going to be your opportunity to really see exactly what they have as far as documentation goes in trying to prove their case, to prove that they own it, to prove how they calculated the amounts owed. So this is a good opportunity for you to see exactly what's going to play out there. The next time that you're actually going to be involved with the court will be at the pre-trial conference. The court is going to mail you out notice. The justice court will. You'll get this in the mail, and there'll be a date and a time where you're supposed to appear at the justice court and meet either with the other attorney or with the judge to really this is really the time when the judge sees the case for the first time. Now, I should tell you, in Maricopa County, where the majority of the cases I deal with, that's where they are. Most of the justice courts, you're not going to meet with the judge at the pretrial conference. A lot of people think this is where they're going to go there and they're finally going to be in front of the judge. Usually that's not the case. Some of them, they still do. You'll go in, the judge will call the case, they'll have the parties come up. They're going to ask you if you've exchanged disclosure statements yet. And usually what's going to happen is then they're going to give you a trial date, and it's going to be several months down the road. It's a very brief meeting. They may ask you if you want to discuss settlement with the opposing attorney, and they'll have you go out in the hall and the parties can discuss if there's any type of middle ground that can be reached. If not, they'll give you a trial date. There are many justice courts, though, where you don't even meet with the judge. Like the Highland Justice Court, I know, for instance, when you show up there, they often take you and the opposing attorney and put you in a conference room and ask you just to discuss if there's possible settlement in the case. If there's no settlement, then you fill out a form just asking the judge for a trial date, and then they will send you a trial date in the mail. You don't even get it on the day of the pretrial conference. So that is generally what those are like. Those are kind of anticlimactic meetings because not a lot happens there. They're over very quickly. But I'll give this one little caveat and warning here. They are important in that if you do not show up, if you don't show up to the pretrial conference, judgment will be entered in full against you. I don't agree with it. I don't think the law supports it, but I can tell you that every single one of the justice courts will do that. If you don't show up to that pretrial conference, or even if you're late, if you're 20 minutes late to that, you're likely going to show up and find out that judgment in full has been entered against you. Also, a little tip I'll give you, if they don't show up, if the attorney for the debt collector doesn't show up, often I see that many of the justice courts will then try to reschedule it and continue it for a later date. It's not fair. I don't agree with that either. They should be entering judgment just like they would do against you. But I'm just telling you what I see on a consistent basis is that the judges will often continue it if the debt collector's attorney doesn't show up. You need to be kind of brave here, be courageous and tell the court, look, they didn't show up. If I wouldn't have shown up, judgment would have been entered against me. I'm going to ask that this be dismissed because they didn't show up to this meeting. And if you request that, what I have found is most courts are going to say, okay, they're in agreement. That if the courts have to agree that if you didn't show up, judgment would have been entered, it should work the other way as well. If they don't show up, you don't want to have this continued. You probably had to take work off to show up to it. And if they didn't bother to show up, then dismissal should occur on the case. And you should ask for it to be dismissed with prejudice, meaning that it can't be refiled again. The court probably won't go for that, but you can still ask for it if their attorney doesn't happen to show up. Now, something I want to bring up that happens in just a few of the justice courts in Maricopa County, if your case is filed in the Northwest facility, which is specifically the McDowell Mountain Justice Court, Desert Ridge Justice Court, and the Dreamy Draw Justice Court, you're likely going to be required to participate in mediation. All the other justice courts don't require it. But what mediation is in those courts, they'll actually send you a date when you have to show up to the courthouse, and you and the opposing side are going to meet with a mediator whose job is to sit down with you and decide if there's some kind of settlement or middle ground that can be reached. It's one of these things where I've seen it kind of be hit and miss, whether it's actually something that's going to resolve your case, but it is something, if you don't show up, there's a high likelihood that judgment will be entered against you. And so it's important to show up. It may be something where you can resolve the case. You shouldn't feel any pressure to resolve it at that point. If you don't, then a trial date's going to be set. So those mediations usually take about an hour, sometimes a little more. But if you can reach an agreement, great. If you don't reach an agreement, then the case will just be set for trial. So after the pretrial conference, after mediation, if you're in some courts, if an agreement has not been reached, if the case has not been settled, then you're going to have a trial date, which is going to be set several months down the road. Now, before this case goes to trial, though, you're almost in 100% of cases going to be hit with what's called a motion for summary judgment. Now, a motion for summary judgment is the debt collector's way of saying, I don't need to go to trial. We think we have enough evidence. We're going to submit these documents to the court and have the judge look at them, and then the judge can tell us whether we're entitled to judgment or not. Now, this is another area where you have to participate. If they file a motion for summary judgment, you need to look at the date that they sent it to you. You then have 30 days to respond in writing to the motion for summary judgment. If you do not respond in 30 days to the motion for summary judgment, then judgment will be entered against you. And it's important to note that this motion for summary judgment is different than responding to the complaint. In the complaint, you're just responding that, whether you're admitting or denying the allegations. That's not how responding to a motion for summary judgment is. In responding to a motion for summary judgment, you have to come in and it has to be substantive. You have to argue the law. You have to argue the facts of why it is that judgment should not be entered against you. So I have a course, an online tutorial on how to do that, again, at consumerwarrior.com. If you go over there, that can kind of walk you through it. This is much more complicated. And the debt collectors know that. They know that most people are not going to be able to respond to this in a substantive way, and they're going to end up getting judgment against you. So it's something, if you're defending yourself and you get hit with a motion for summary judgment, my recommendation, go over to my website, consumerwarrior.com. I'll put a link below the video. But there's some information and tutorials there on how you can help yourself respond to that in a more substantive way. Then if you prevail and you are able to defeat the motion for summary judgment, then the case will actually go to trial. Now, cases like this are generally bench trials, and meaning that there's not a jury there. You can request a jury if you'd like one, but most of them don't. It's much more complicated. It's a much more lengthy process. Most of these judgments are dealt with in a bench trial manner, and they take less than an hour. It doesn't take a long time for the evidence to be presented and for you to make any defenses. So once the judgment or once the trial is over, the court can do one of two things. Sometimes the court will enter a ruling right then. Sometimes they'll do what's called taking it under advisement. If they take it under advisement, then at that point, you'll probably get a ruling 2 weeks to a month, sometimes longer down the road, where they'll mail you something in the mail telling you whether you've won or whether you've lost on it. Most of the justice courts, though, are submitting their rulings from the bench. You probably should get something right then. If you prevailed, or even if you didn't prevail, a judgment will be entered either for or against you. And then at that point, there is a 14-day window where you can appeal if you don't like the ruling that the judge entered. Now, that's a very hard and fast rule. It's 14 days. If you don't file an appeal to the Superior Court, the judgment is final and the case is done. So that's generally what you're looking at for process in Arizona justice courts, debt collection lawsuits. The process is the same pretty much over and over and over again. And as you can see, there's a lot of little pitfall areas where if you don't file an answer, you don't show up to the pretrial conference, if you don't show up to mediation, or if you don't respond to the motion for summary judgment, the judgment could be entered against you. And so that's really one of the main reasons I've done this video is you need to know what those are, because I meet with people all the time who are served with a motion for summary judgment and they don't respond to it because they think they can just show up to court and tell their side of the story. That's not the case. You must respond to it. Or they show up 20 minutes late to a pretrial conference and then they're surprised that judgment has been entered without the plaintiff having to even put on any evidence, really. Again, I don't agree with it, but I'm just telling you that that's a reality of those situations. So that's what you're looking at if you're dealing with a debt collection lawsuit in the state of Arizona and you're in the justice court system. If you would like some assistance with that, we represent people in the justice courts all day long. It's what I do. We deal with a lot of these debt collection cases in helping people to present their best evidence and doing all they can to avoid a judgment in this. You can head on over to my website at consumerwarrior.com. We have a consultation where I'm happy to go over your case and let you know if it's a good one that you should pursue as far as defending against it. Or you can check for more videos here on how to defend yourself. I also have templates and tutorials over my website at consumerwarrior.com. But I appreciate you watching today.